Okay, now we're recording. Good evening, folks, and welcome to our presentation tonight on To Be Spoken To Court, as put on by Community Legal Services Clinic at Western Law in partnership with Rights and Responsibility Awareness Initiative. Heatham Karki couldn't make it tonight, but he is the wonderful human being who helps us put this out and cast a wider net to our community. They also make sure that this presentation is translated into multiple languages so we can cast an even wider net. So we really appreciate folks watching this. This will be a short presentation. I like to say bite-sized, so that it's short and sweet, not a whole lot of information, but basic information that I find is really helpful for folks who don't have a lawyer and are unrepresented in family court. So we'll be talking about To Be Spoken To Court, which occurs on Tuesdays, which the law students here tonight will talk about. We have law student Sierra Olson and law student Maria Talha, and they will be doing the presentation. We may have a short Q&A after if anybody has any questions. So I'll just pass it along to them and mute and turn my video off. Okay, thanks a lot.
Thank you, Greg. My name's Sierra. I'm a first-year law student and associate caseworker with the Community Legal Services Clinic, and myself and my fellow caseworker, Maria, will be giving this presentation today. First, we would like to begin by acknowledging, sorry, 1 minute. There we go. We'd like to begin by acknowledging that Western University is located on the traditional lands of the Anishinaabeg, Haudenosaunee, Lenape-Wook, and Chinungton nations, on lands connected with the London Township and Sombra Treaties of 1796 and the Dish with One Spoon Covenant Wampum. With this, we respect the long-standing relationships that Indigenous nations have to this land, as they are the original caretakers. We acknowledge historical and ongoing injustices that Indigenous peoples, First Nations, Métis, and Inuit endure in Canada, and we at Western accept responsibility as a public institution to contribute toward revealing and correcting miseducation, as well as renewing respectful relationships with Indigenous communities through our teaching, research, and community service. So before we get into it, we'll start with a short disclaimer. This is not a legal advice session. This is simply a public legal education session that will provide basic and general information with respect to be spoken to appearances. There will be a question and answer session at the end of the presentation, and you'll be able to ask Greg questions at that time. However, only very general advice can be given. Please don't rely on this information as specific advice for your specific circumstances. We strongly encourage you to seek legal advice of your own for your specific issues. Additionally, this session is being recorded and it will be distributed publicly. So there's no confidentiality provided during the presentation or the Q&A session. So please don't talk about private matters during the Q&A session if you don't want the public to know about them. Additionally, we as students cannot give legal advice. We are only able to give you public legal education. Despite our growing knowledge of the law, we still can't give legal advice during any time of the presentation. So to begin, a To Be Spoken To court, it can kind of be thought of as a placeholder date in your court proceeding. So it's just an opportunity for the parties to update the court on what the next steps in the proceeding is going to be. In London, To Be Spoken To appearances are generally held on Tuesdays beginning at 9 a.m. On some days, there can be over 50 cases on the list that day, and only one judge is assigned to address all these cases. The list is also referred to as a docket. The judge on the To Be Spoken To day has not read your case or your file over prior to the to be spoken to appearance. And their primary purpose of the to be spoken to day is just to move your case forward to the next appropriate step. That's it. Because of the size of the docket, the judge does not have the time to determine non-procedural issues in your case, so they aren't able to make decisions on child support, decision-making, parenting time, etc. If they did, there just wouldn't be enough time to get through the whole list. The judge, even if they had time to determine your non-procedural issues, they can't because they're not familiar with your case. A to be spoken to appearance is not a motion or a hearing. It's not an opportunity to argue your case or specific issues about your case in front of the judge. To be spoken to appearances are still held over Zoom. This may be because of the volume of participants on that day. So when on Zoom, be sure to have your Zoom name display exactly as your name shows up on your court documents. So before you log on, make sure you go and change your display name to the name that will appear on the documents. It may also be helpful to the court for you to include in your name what docket number you are on. So your display name can be your first name, last name, and then number, say 23. When you're on Zoom, make sure to keep your microphone muted and your video off until your matter is called by the court. Or you are in the registrar's court at 9 a.m. and would like to speak to your matter at that time. So to be spoken to appearances come in two stages. The first stage is at 9 a.m. before the registrar, and then at 9:30 before the justice. So if you'd like to know what number you are on the docket, you can obtain the docket at the Middlesex Law Association website. That's midlaw.on.ca. It's normally up at 4:30 the day before. If it hasn't been updated, just keep checking. They'll have a daily docket bucket button where you can click and download the docket and see what number you are for the next day's appearance. So the 9 a.m. registrar appearance, they happen between 9 a.m. and 9:30 a.m. Sometimes they're subject to technological hiccups, so if you log on and the video hasn't started or the meeting hasn't started, just be patient. They sometimes have a couple technological difficulties, but yeah, just wait there. The registrar is only able to deal with matters that are being addressed by the parties on consent, meaning both parties have already consulted with each other and they've agreed on how the case will proceed next. So if you and the other party or the other party's lawyer have agreed on what the next steps are in the case prior to your appearance, then you can both sign on to Zoom at 9 and address your matter with the registrar, so you won't have to wait around for the judge to come out at 9:30 and to work through the docket in order. If you are both unrepresented parties and you want to call your matter on the registrar's time, be sure to know the following, and Maria will take it from here.
If you are addressing your matter on the 9 a.m. list. Next slide, please. If you're addressing your matter on the 9 a.m. list, you will have to call your own matter. This means that you'll have to turn your video on and unmute so that you can ask the registrar if you may speak to your matter. But if someone else is talking, please don't speak until they're done and the registrar has disposed of their matter. And when you're spoken to, please address the registrar correctly, call them the registrar. And when the court does call on you, you can address them by specifically stating the matter number on your docket, your court file numbers, and the name of the parties. This will let the registrar know exactly what matter you want to speak to, and it will make the process that much easier and quicker for yourself and the other people who are also waiting. When you have the registrar's attention, they will want to know what you are adjourning for and the date you would like to adjourn to. You will need to know how far out you would like to go in terms of the date, and ideally you've already agreed on a date prior with the parties and the council. Make sure you know the date and approximately how far you want your next appearance to be. And if there is no agreement made as of yet on where to go next, you will be shifted to the 9:30 list. And again, um,
Sorry, am I on the wrong slide,
uh,
Maria?
yes, this would be slide 13, which is just the one after this one.
This one?
The one, sorry, it's just it's above this one. And then below that again, the next slide. Yes,
Okay,
perfect.
thank you. Sorry about that, folks.
Problem. And again, court is generally started by 9:30 a.m. unless subject to technical issues. Now, because you're subject to the judge's control of the docket and they go in order of the file, so be prepared to wait. If you're at work, be prepared to be on standby for quite some time while with the court while you're at work, and do not keep working or start walking around when your matter is called and while you're talking to the judge. Make sure that when your matter is called, um, that you give the court your undivided attention and be prepared to proceed. But again, until they call your matter, keep your video and your sound off. And you don't have to call your own matter. You don't have to repeat the file number or parties' names. The to be spoken to court will call it for you. And here are some of the tips, the best things you can do to prepare for when your matter is called. Keep your video and sound off until your file is called. Make sure you know and listen for your file number, the names of the parties, and how your file started. Did it start by way of an application, motion to change, contempt motion? Some judges will want to know how the file originated. Also, when was your last court date? What was it for? Have you had a case conference since? This is all very important information that you would like to have on hand. Where would you like it to go from there? What would you like your next appearance to be? It's important to know the issues of your case. If it's about child support, parenting, any other matter, the judge may want to know the general outline of the case. And this is not the time to explain your position or the other side. And it's not time to talk about decision making. This is just the judge collecting a general idea of the case. And if you have had a case conference and you don't know what the next steps are, you may want to have a settlement conference. You cannot go to trial without a settlement conference, so be prepared for a long process, as settlement conferences are booked months in advance and trials are being booked a year out. Think about how you want to use your time wisely to move your matter forward. So there may be scenarios where you may not want to go to be spoken to court because you're waiting on information from the other side, whether that information is financial disclosure, financial information, medical information, or you could be waiting on records from, for example, the Office of the Children's Lawyer, or Children's Aid Society, and these records can take a while to come in. So the courts are going to want all of that information on hand. So you don't want to book a settlement conference for 2 months away for records that are probably going to take 4 months to come in, right? It would be wise to either book a later conference date, if you could get one, or set up another placeholder to be spoken to court date. It's important to remember that to be spoken to court dates should be taken as placeholder dates to track the progress of your matter and to briefly update the court on where you're going from there. When you address the judge, please refer to them as Your Honor. Please do not speak over other parties or the opposing party or a lawyer directly in court. Please don't speak over other folks who are also making their submissions, because that makes the court process extremely distracting, and it may increase the time it takes to reach your case as well. When everyone is done talking, the judge will address you and then you can speak. Please make sure that you know your case and where you need to go with it and where the case has been. Please keep your details to the point, because again, it's not the time to tell them about the entire history of a case and everything that's happened and what you would like to happen, because the judge can't do anything about that at this point, especially in the to be spoken to court date. All they can do is book another day for you that is appropriate to move this matter along. And lastly, please don't be shy to ask for help and make use of the free legal resources available to you, such as this PowerPoint, which is facilitated by the Community Legal Services and Rights and Responsibilities Initiative. We will now be having a Q&A session with the supervising lawyer, Greg Perrick, but please keep in mind that these questions will be seen by everyone, and this session is being recorded and will be posted online, so please keep your questions general rather than specific. Thank you so much.
Okay, thank you, folks. I appreciate that. That's very good information for everyone. So if anybody has any questions, general questions that they may have just about the court process, you can put your question in the chat. You can unmute and just ask, but just remember I can only answer general questions. But I can talk in the meantime, just to elaborate on what Sierra and Maria said. The best thing to take away from this is to be prepared as possible for each and every appearance, even outside of to be spoken to dates. Because there is an expectation from the court that unrepresented parties be as prepared as a lawyer would be. Now, you're definitely gonna get a lot of indulgence from the court and some patience on their end for sure, and that's great, and that should happen. But their patience can run thin, and you want to make sure that doesn't happen, because you don't want to get a judge on their bad side. So be prepared as possible. Like they both talked about, know what's happening in your case, know what the last court date was for, and know where it's going and why you want to go there. But also make sure that, so if you're looking for some help from duty counsel, which is a free lawyer on site at the courthouse, on the second floor of the courthouse. There is the family law kind of area, and there is duty counsel there. And you can go talk to duty counsel. But what you should do, and watch this back, and watch this recording back and see the resources at the end, because what you should do is call duty counsel ahead of time, and well ahead of time. If you show up the day of, your motion or whatever is going on, and you're now looking for a duty counsel's help on that day, you're probably going to be not getting full service, or perhaps not getting service at all. And they also have to take time to see if you financially qualify for those services. And so all of that needs to be done. So the sooner you can, reach out to duty counsel for some assistance, do so. The best thing you can do is for your case in all respects is to get on things as soon as possible. Like we say in one of the last slides there, don't be shy to ask for help. Family law is incredibly can be incredibly confusing, and it's convoluted even for lawyers. There's tons of forms. Each form, expects something different, and printing out forms and signing them and having them commissioned by people who can do that. All of that takes time. And so the sooner folks can get on top of that stuff, the better place you'll be in at court. Because what happens is, if you're not prepared for court, you risk nothing happening that day. And if the other side, the opposing parties, are prepared and you're not, you could open yourself up to a cost consequences, which is perhaps legal costs being thrown away for that day, because the other lawyer was prepared, the opposing party's lawyer was prepared, ready to go, and nothing happened that day. Well, a lawyer is allowed to, in that circumstance, ask for, you to pay their client's legal costs for that wasted appearance. So there is like real world consequences to not being prepared. And so make sure again that you're asking questions early and often, to make sure you know what you need to know. The resources that we provided in the last slides there, it can help you narrow down the issues that you need to know. Call the Law Society referral service. That's 30 minutes of free advice from a lawyer, and then you get a referral, perhaps to lawyers in the area who may be able to take you on as a client. Call the Family Law Information Center at the London Courthouse, and call them often and as soon as possible, perhaps to get some information there. I used to do the Family Law Information Clinic twice a week in St. Thomas, Ontario, and I think it was always helpful because you can at least get 20 minutes of general information about what needs to be done from a procedural standpoint. And again, that may be subject to financial eligibility, but that's a resource out there too. You can also go to stepstojustice.ca. That is a great resource for kind of giving you basic general information about how to organize your case and what documents need to be filed and when they need to be filed. Things like that. Even start from Googling it if you can, but you only get out what you put into it. And I know that family law and law in general can be very, very overwhelming and intimidating and can be inaccessible. But the reason we have these short presentations at the end of the day is to try to make the law more accessible for folks who can't afford a lawyer. And that may need just general information about how to move their case forward, or general information that may solve why they keep going to court and it keeps getting adjourned, things like that. It can be an incredibly frustrating and isolating experience. So that's why we do this, so that we can give folks at least basic information that they can use to build on to get more specific information from other resources out there. That's my usual rant that I know the students have heard all the time and are probably tired of. But it really means something for us here to be able to even give a little small sample size of information, but it really goes a long way if you take us up on that. Any questions?
Hi, my name is Alexis, and I have a general question. I believe the opposite party. I'm not even sure where to start, but will I be able to present in court previous cases of there is this entity, I believe it's called child protection. I'm not sure what they are called. There are 3 documented cases or 3 separate episodes of us having to have child services come to our house to make sure that my husband was kind of behaving properly with the kids and stuff. Will I be able to get access to that information and be able to present it in court in order for kind of the judge be inclined towards not giving my husband rights over the kids, and hopefully I will get full custody because of this past history with child services?
I got you. Okay, so thanks for the question. So I think, and correct me if I'm wrong, what you're asking is essentially, can I get the records from this Children's Aid Society?
Right.
Yes, yeah, 100% you can. They're on their website. There is an area where you can click on for more information to request their records, the release of personal information or their notes that the caseworkers may take. However, what if you're in court, the best thing to do is to try to have the court order that, because if you just ask for the CAS records by yourself and there's no agreement from the opposing party to have them released, what they will do is they can release it to you, but they will redact all the information that doesn't that has nothing to do with you, because the other side hasn't given consent or agreed to have that information released. And until they agree or the court orders, it's going to be confidential information and for them because they didn't consent for that private information to be released. So it wouldn't be as helpful if it just released to you and the rest is blacked out and redacted. So I can't speak specifically to your case, but if there is an opportunity at a conference, case conference, settlement conference, to ask for a release of the CAS records, that may be in agreement with the other side, and that could be ordered. But if the other side doesn't agree, you'd have to bring a motion, which I is not the scope of our presentation tonight.
Right.
But I would encourage you to use those resources that we put in the slides to ask about that. But yeah, there's definitely an avenue where you can get that information and eventually and hopefully put it before the court. Does that help?
Yes, perfect. Thank you so much.
No problem. Any other questions? I think I saw that the advertisement for tonight says child protection rights. I apologize to those who were under the impression that tonight was about child protection issues. Tonight is about to be spoken to court generally. However, we will be doing maybe next month or the month after that. We will be doing a presentation with respect to child protection rights, and we will also be doing a similar presentation, hopefully at LOSA in May, on site to provide some information there as well. So don't Alexis, if you have further questions at that time about child protection information, I encourage you to attend that one.
Thank you.
No problem. Sierra, I know you mentioned, I just remember now that we skipped over slide 10. Do you want to just give the short information there?
Sure. So slide 10, just if you are both unrepresented parties and you want to call your matter on the registrars list at 9 a.m., just make sure that you have, off the top of your head, make sure that you know the file name. So just Smith versus Smith or whatever it is. Make sure that you have your docket number handy, so the number that your matter is to be called on the court's list of matters that day. And also make sure that you have your court file number handy. It'll look something like FC dash 2 numbers dash about 6 numbers and then dash 4 numbers. The FC stands for family court. The first 2 numbers indicate the year that your family first started an application in court. So if it looks like FC 23000001, that means that your matter would have been the first matter to start in the year of 2023 in family court. And then the final 4 numbers indicate what volume your case is at. So if you already have a final order and you've brought a motion to change, then your volume number will be 001. These are the last 4 digits. And then so on as subsequent motions to change may be brought by either party in the future. That's everything.
Yes, thanks for that, Sierra. I put a kind of an example of what you were talking about in the chat. Because folks will see all of those numbers and letters and have no idea what they mean, understandably so. But that is your court file number. And that's how you call your matter when you'll hear that in court. The registrar, if you're subject to the judge, like we said earlier, subject to the judge's kind of control of the docket, the court will call it, and you'll hear them say something like, for the example I put in the chat, if I can pull it up, there it is. You'll hear them say something like 45 of 23. And what that means, as Sierra just outlined, was, so this would have been the 45th case that started in 2023, but they will say it as either 45 of 23 or 45 for 23. Either way, it means the same thing. And so listen for that. If you hear that, over the PA, if you're in court, or if you are on Zoom and you hear it called, and then if you're on the registrar's list and you want to call it and you want to say it exactly how the registrar usually hears it, you would say, whatever that second number is. So again, 45 of 23. And then you would say, Smith v. Smith. And then that way they know exactly what they're looking for. And what, like it was mentioned in the slides and in the presentation, sometimes saying the docket number, like if you're fifth on the list that day, sometimes that's not enough just to say it, because the docket is subject to change at the last minute, and your number 5 may not be the court's number 5 on the list. So saying all of that information is helpful. My advice to folks would be to, at least on one page, just have right in front of you while you're on Zoom or you're in court, your court file number, how the case was started, the court name, what you did last, and what you need to do now, and what the issues are of the case. Just like a one page, you don't have to write any of your arguments or anything like that, but just that general identifying information is so helpful for the court. Judges really appreciate when anyone, including counsel, lawyers, are extra prepared, and they're extra happy when unrepresented parties are prepared. It really makes a difference. I am more open to hear folks make an argument when they're prepared and they're ready. I'm less open to hearing arguments, like I think anybody is, when it's just all over the place and you can't even kind of pin down what's going on. So like it said in the slide, know your case and keep your comments to the point, because again, Tuesday morning is not even close to the appearance that you need to argue your case. It's where we're going or where we've been and where we're going. And use all of those resources that we put in the slide, because I know how hard it is these days, especially in this area, to get a lawyer. Especially from a family law perspective. Every family lawyer I know in town is super busy, likely not taking on clients, and unfortunately, and I get it, and this is not a criticism, but likely not in a position to take legal aid matters. And so that means we have to find different ways to make sure that unrepresented parties are armed and ready for court. And just little presentations like this and providing you with different resources is, I think, a big step in doing that. If you can just at least remember these small things, I think it will help greatly. Any other questions? You don't need to. No pressure there. And definitely, watch this again if you need to. And we'll be having other presentations in the future. And like I said, our next one will be it will be focused on child protection issues or child protection rights, or more. I think commonly you'll hear Children's Aid Society issues. Okay, so I'll just wait a couple of beats to see if anybody else has any more questions. I do appreciate the folks who attended. Um, and like I said, this will be boosted out to other folks in multiple languages, and we appreciate those others who are going to watch, and continue to watch all of Rights and Responsibility awareness initiatives, multiple presentations. I know they have a large bank of presentations that they do, and they keep up that good work, and we appreciate they're partnering with us and helping us cast a wider net. All right, so I'm going to stop recording. Thank you, folks. You can log off now. Sierra and Maria do not.